Hey legal team, welcome once again to Fitz in Law School. I'm Fitz, and I know what you're thinking. Fitz, what the hell, man? You've been gone for so long. We haven't had a video in so long. And that's true. And the reason is because of two things. First, I was dealing with moot court and my moot court competition. And second, was dealing with finals. So we're just going to talk about those two things. But first of all, we need a celebration. We need the celebratory blowing of the horns in Fitz in Law School because not only are we done with finals, congrats to everyone who did that, but also we're halfway through law school. We are one half of the way through law school. We are 3 semesters down. We have 3 semesters to go. That math checks out. I've run it many, many times, and I can't believe it. It's so exciting. So all of you who are doing this stuff, all of you who are watching in the future, whatever, congrats. Nice work, everyone. You did it. Okay, so now let's one more. So let's talk about my moot court competition first. So I had a moot court competition. It was the Chicago Bar Moot Court Competition, and it was in Chicago. In previous episodes, we had talked about the problem and what the problem was all about, and essentially what side my team was writing for. And then at the competition, what we had to do is we had to argue both sides. So that's what we did. So we were writing for the petitioner, which was the guy who was claiming that he had been discriminated against and all that stuff. And so we did 3 rounds, and unfortunately, we did not make it to the Sweet 16, which sucks. And the rankings of the teams came out like 2 weeks ago or something like that, and we were number 17, which is really frustrating. But I don't know. We did well. There were 32 teams, and so that means we did pretty good, which is great. But so essentially we went and we argued first the petitioner, then the respondent, then petitioner again. And so that means that I was with one of my partners the first round, the other one the second round, and then back to the first partner the third round. And it was really fun. It was also really fun to be in Chicago. Like, yes, it might have been a little cold, but, it's not that big of a deal. Went to a bunch of great restaurants and bars and, enjoyed ourselves on top of doing the competition and stuff. And it was really, really hard work. We went and I'd rather just talk about like the days of the competition. So we did this over 2 days. So the first day we went once as petitioner, and then the second one as respondent, and then the last one we only went once. So the first day everyone was kind of super nervous and stuff, and of course you are. Like, this is the first time not only the first time that all 3 of us had ever done a moot court competition, but also like this is the thing that we've finally been going and preparing for. And so what's interesting is that you don't know what the judges are going to ask. I mean, you can kind of figure it because, like, I don't know about what other teams do out there, but I know that at Hastings we have like 30 practices, like 30 oral argument practices like beforehand. And so we just completely go all out to really, really make sure that we do well. And so we're asked every question under the sun. And so it's unlikely that you're going to get any questions that you haven't really heard before. But the challenging part is that sometimes the judges don't ask questions. And that's kind of what happened in our first round. Like, my partner went first, and she was dealing with the like jurisdictional issue and all that stuff, and I was going second. And she got like probably 4 questions in her total 15 minutes, and I got like 5 or 6. And the jurisdiction question is the more complicated of the two and the more kind of confusing of the two. So I would kind of get if the judges didn't have that many questions about that. Mine is a little bit more like, one of my professors called it a crunchy issue, in that there are more things for you to like bite into. There are more things for you to understand, like easily understand without reading the bench memo or anything like that. You can stop and say, oh, I kind of recognize some of those cases, or I recognize some of those things. And then the big deal that will kind of haunt me for the rest of my life is that I had a second in the first round that we did, where I was answering a question, and then I can't even remember what the question was, but the judge went and asked the question, and then I said probably like a sentence or something, and then I started my second sentence, and I said to to do that. And I just had like one of those parts where I just kind of blanked out a little bit. And I know that's super normal, and I know that happens all the time, but God, that really bothered me. And so I really hope that was not the thing that really set us over, but who knows what'll happen. And then the second round and third round, we did really, really well. All of us were given compliments throughout each one of those rounds and stuff. And so, it was really, really fun. It was interesting to go up against other teams and see what their style of speaking is, because it seems like our style of speaking is a little bit more, not narrative, but just reasonable kind of, like it seems like most of the people that I work with don't really do the trial style kind of thing. And by trial, I mean, like, there's this saying that I always really, really like. And this saying that a lot of lawyers know, and I guarantee you'll be able to ask any lawyer and they'll probably know it, is if the law doesn't support the lawyer, he pounds the facts. If the facts don't support the lawyer, he pounds the law. If the facts and the law don't support the lawyer, he pounds the table. And what that means is essentially making, a big stink about it, or saying like, Your Honor, this is a issue that cannot be let go because it's about the right thing to do, but it's becoming passionate about it, so that it essentially kind of distracts from both the law and the facts. But whenever you have someone who is eloquent and arguing their point, but also very, very fiery and passionate about it, there's a very delicate balance there. I think there's a risk to doing that, but you also, that has a certain way of convincing people. And so I think that maybe that might be, and of course, like, there are regional preferences and stuff. So people in places around the country are, especially when they have a law school in them, they're probably primarily supplied by those people who are in that law school. And so that means that what's the preferential kind of way that those lawyers and those law schools teach, that's probably what the lawyers in that area are going to prefer. And so I'm not sure how Chicago Law School, teaches their stuff or teaches moot court or anything. However, I do know and I do understand that it seems like there are certain regions that prefer different ways of speaking and different ways of arguing and stuff. And it seems like they preferred the trial advocacy way of doing that, because there were several schools that we went up against who did that kind of thing and they moved on. And it seems like sometimes they didn't have the best points that they possibly could. And so it could have been, again, I don't want to speculate because I don't want to blame, various, things that I don't know are actually the case. But it seems like trial advocacy is a way in which you can handle moot court. I don't particularly like it. I think that I would be distracted no matter what they were saying. I'd be very distracted with someone yelling at you, essentially, which is I don't think, for some of the people that we face, I don't think that that's actually an exaggeration. They were kind of loud and kind of yelling, and so I don't know, whatever. But yeah, so that was a great experience, and I'm assigned to a new team this semester, and I don't want to talk about it too much because I don't want to as I've gained more information and stuff, I don't think that I should be talking about like what the problem is or what team I'm on, because on the off chance that someone in the competition sees me, they think, oh, that's Fitz and he goes at Hastings, so we know what competition he's on, and that's not good, because then they come in with a bias. And also, usually the vast majority of the time, each one of these competitions, the judges don't know what school you're from, and so you're assigned a letter, and so that's what you do. But all I can say is that it's an area of law that I know nothing about, and that's going to be really, really interesting to argue that and to learn all about this new area of law that I know nothing about. So, cool stuff. Next, we have my finals. So I had 4 finals this semester. I had my evidence final, and then I had professional responsibility, I had administrative law, and I had constitutional law 1. So just going through each one of these, my evidence final was it was not terrible. It was not too bad. I was really struck and really reminded of some of the advice that one of my lawyer mentor guys gave me over the summer, which was saying that he wished that he would have really, really focused on evidence, because evidence comes up way more than you think it does. Just in your general practice, even if you're not doing trial advocacy. And so I really, really tried to keep that in mind as I was studying each one of those. Evidence was interesting, and the amount of things that were presented in that fact pattern kind of signify how many different ways evidence can be brought up. And so that's really great. I had a fantastic professor, and so I'm taking him next semester, like this coming semester, for criminal procedure. So that should be really fun, and I can't wait for that. My second final was professional responsibility. So professional responsibility was kind of an interesting exam. It was all about like their ethical rules that govern how a lawyer can operate. And so this class was designed to kind of introduce those to you, and then like essentially give you like fact pattern after fact pattern about ethical dilemmas, and you kind of identifying or issue spotting each one of the ethical rules that would be in play and like how it would be treated and all that stuff. And a lot of people use this class to study for the MPRE. So the MPRE is this big multiple choice exam that you have to take before you become a lawyer. But essentially it is an exam that just tests you on the ethical rules of being a lawyer. And so our exam was pretty much just a huge, long, complicated fact pattern. And then you just had to issue spot. You had to say, all right, here's this issue, and here's the rule that's invoked, and then here's how it's treated, and all that stuff. And so that was interesting. It's the rules are pretty intuitive. The ethical rules are pretty intuitive, but the application sometimes can be tough, because nowadays, like, one of the biggest ethical dilemmas that lawyers face is like conflicts of interest, because so many companies overlap, especially if you're in like a specialized thing like the tech world. You're just going to be surrounded not only by former clients, but also like our fact pattern was you're serving a former client, or you're serving a client, and then all of a sudden that client gets bought up by one of your former employers. Your former clients. And so like, how do you treat that? And here's the other layers of that. But it's complicated. And so because of that, lawyers have to start kind of doing this analysis more and more often about saying how much of a conflict of interest they have when they're representing each one of these clients. And so it's not only is it a very important thing to note, but also there can be real consequences if you don't follow these things. I mean, I don't know what's going to be happening with Michael Cohen. I think he might have gotten disbarred from New York, but I'm not entirely sure. But he was lying and harassing people and all that stuff. So I don't know, why wouldn't he? But you can get disbarred for violating ethical rules and all that stuff. So it's serious stuff. So study up on that. My third final was administrative law. So administrative law was weird. And the reason it is weird is because it's an actually confusing topic. Like, the Supreme Court has given very conflicting opinions on the couple different ways to think about administrative law. So administrative law is the administrative state is an enormous part of the federal government, and it's all in the executive agency, or it's all in the executive branch through agencies. So what that is that's Congress that's delegating its various responsibilities to the executive branch and to specific federal agencies. So the vast majority of these agencies, all of them essentially, they're not supposed to really be around. Like, they're not prescribed in the Constitution or anything like that. The main ones are like the Department of Defense, which used to be the Department of War. That's not, like, none of these agencies are in the Constitution. However, like, it invokes like the necessary and proper clause about Congress making sure that it's able to carry out its duties and can take and pass and stuff all laws that are necessary and proper to execute these laws. And then they delegate certain powers to these executive agencies in order to do that and to do that effectively. But they also have to balance between not delegating too much of their power, because that violates the non-delegation clause or the non-delegation rule. But then where kind of the courts come in is the courts go and review decisions that are made by those executive agencies or the delegation of the power in the first place. So executive agencies go and make decisions, and then courts have to, if they're sued, then courts have to make sure that they follow all the rules and follow the procedures. They have to make sure that they like give adequate reasons. The vast majority of the time, agencies can't just make decisions. And then because, if you think about it, the vast majority of the way that people interact with the federal government is basically through two ways. One, it's through taxes, and second, it's through administrative agencies. You apply for grants and stuff. Like I am getting student loans from the Department of Education. That's an executive agency. Nearly everything that you do is actually dealing directly with the executive branch rather than with congressional or judicial branch. Most of the time, you're not in federal court. So that's kind of the way that to deal with it. And then there are three different styles of review for executive agencies for those decisions. And so the courts have gone back and forth on which standard should be used for each one of those agencies, and it's very confusing. And so the final was confusing, not terrible, but it was confusing. And everyone was on the same page with that. They're saying, oh yeah, it's pretty confusing. And then my last one was my constitutional law class, my favorite class so far. It was so interesting. I love learning about the Constitution, and my professor was great too. So I'm going to be taking him next semester as well for Con Law 2. And that essentially was like multiple choice and then short answer and then one essay. And it was a really, really fascinating fact pattern. And of course, with Donald Trump and with the impeachment and all that stuff, there was lots of stuff that essentially we just ask about what the Constitution says and all that stuff. So it was very, very interesting. But next semester, going into next semester, so let's see, I'm going to be busier next semester than I was this semester, which is crazy to think about. But I have my moot court competition. I am TAing for one of our legal research and writing classes. And then I have business associations. I'm doing it's essentially like the United States and Chinese law class. And the reason I'm doing that is because, with the expansion of China and with their economic power and stuff, it's very, very important, I think, to kind of know at the very least the minimal background about China's law and about how they deal with things, about how our companies are able to deal with that stuff. So I think that'd be a really, really interesting part of my legal education to add on to. And then I'm doing constitutional law 2. And lastly, I am doing criminal procedure. So that's a lot of stuff. So yeah. But it's going to be interesting. It's going to be fun. I'm never going to be bored. I'm always going to be busy. I'm going to have a nice tight schedule, which will keep me from not being distracted, not being able to procrastinate and all that stuff. So that's great. And I'm actually already working on my moot court stuff right now, even before the year begins. So yeah. But hey, that's law school for you. So everyone, I hope you all have a fantastic break. I hope you all have a fantastic holiday. And let's get back to it, man. Let's get back to the next year, 2020. Got an election year coming up. The impeachment just happened. And so there's so much interesting stuff that's going on in the world. And make sure to look at it through your legal eye, because it's always very interesting to and make sure you don't get bogged down by the politics of some of these things. All right, look at it through your legal eye. All right, so have a good holiday, everyone. See ya.